So, next up, we've got a masterclass. Yolelwa, Sikunyana. Yolelwa is in the building. Yolelwa is in the building. Yolelwa is in the building. She's going to give us a masterclass on small business legal. Sit back, relax, and enjoy. Please come this side, Mr. Stone. Mabopane. Not like that. That's not the energy. Come on, ladies and gentlemen, let's put our hands together for Yolelwa, Sikunyana, masterclass on small business legal. That's the energy I'm talking about. All right, please come on stage. Yeah, there's a screen here.
Dumelang, Sanbonani. You heard earlier, my colleague from Nedbank told you about contractual issues, right? But now, as businesses, we want to use these instruments as a framework to run our businesses. So I want to share with you today, how can you use a contract as an instrument to facilitate your intentions, right? Because remember, you meet someone at Mark and Bean and you guys have big dreams. What follows is we want to register a business, maybe you are friends, old friends, but you don't sign anything. And then 1 year down the line, that person has another opportunity, they have abandoned the business. But in the meantime, you are left hustling in the business. So what does that mean for your rights? Because in the meantime, you can succeed, but you've got a director, you've got a shareholder that owns your business, but you didn't enter into correct legal instrument. So now today is all about talking terms of contracts, understanding what contracts are all about. Who in the audience, by a show of hands, has ever done a verbal agreement and it didn't go well? Right. So mostly, the question is not whether a verbal agreement is enforceable or not. It is enforceable because it's an agreement between two people, but these people, they just shook hands. There was no witness, right? So what are the chances that you are going to be able to prove that you actually concluded a contract? Because it was the two of you, you shook hands and you relied on trust. Alternatively, you relied on the creator that things will go okay. But then they don't, right? So the reason why we have contracts is because contracts are created to secure our investments. If you don't have a written contract, you are gambling with your investment. So if, as an example, you take your pension and you go open a business and then you invite a partner, and because you know each other, you don't conclude any contract, that's a gamble for your business. The second thing that is important about contracts is that it tells us who must do what by when. And when we are happy, like my colleague said, nobody wants to know what is the terms in the contract. But when we fight, this is when we pull out a contract and get surprised what we signed up for. So because in business, it is often that we're going to enter into written contracts. So it's important for us to say, how can I use this agreement that I have signed as a tool to protect my interests and to drive my vision? So signing a contract without reading it or without even asking for an advice, what are the implications of this contract, then it's a risk for your business. So in essence, if we enter into contracts purely for securing money in the bag and we don't read, we are likely to experience troubles, right? So now, if we go to the terms of the contract, right? We have entered into a verbal agreement. We haven't agreed that this verbal agreement is going to be in writing later on. So we just carry on, things are going fine, and later on, you've got a dispute. The very first thing that the court wants to know, was there an agreement? That is the first question. Was there a meeting of the minds between these people that are in front of us? So what is a contract for you? Is that it's a legally enforceable agreement between two or more parties. It doesn't have to be companies. It can be an individual to an individual, or it can be a company to a company, or it can be a company with an individual. So it must tell you, this contract, if it doesn't tell you when and how you're supposed to perform, then it is lacking in essentials. What happens if we fight? Because when there are good days, we don't worry, but what happens when we fight? So a proper contract should tell you that if somebody doesn't pay your invoice, as an example, on the 30 days which they've agreed to pay you, what is your situation under the circumstances? So usually you will go and see, do I need to give this person a notice to remind them that, remember we agreed that you're gonna pay me in 30 days. So what usually happens, we relax as small businesses because we are scared to exercise our rights, because we're not sure who we're going to offend if we enforce our rights or if we demand that another person performs in terms of the contract. So usually it takes time, and later on it becomes a legal problem, which means legal action must now be taken because we didn't use this contract as a legal tool to protect our interests. So that is why when you have a contract, you want to know what are these provisions if there are negative situations. That drives you to achieve. Now, we know that when you meet people for the first time, there is no trust. But there is what we call a non-disclosure agreement. Who has ever signed a non-disclosure agreement? Right. Thank you. So a non-disclosure agreement, it's designed purely to make sure that when you interact with a potential partner or a potential business, your conversations or your commercial secrets are protected under that agreement. But that agreement works to the extent that you are working with someone that is honest. Someone who's dishonest, then they can violate that agreement anytime. But for you as a small business, you mitigate your risk. Because usually what we hear is that I went to pitch and told someone about my idea, they rejected it, and later on it mushroomed exactly as I had pitched it. But that is a problem. You didn't mitigate your risk. My colleague earlier told you about types of intellectual property. One that is important that she shared with you was that there's a copyright, which doesn't need registration. It accrues automatically for original work. So how many of us create proposals, create commercial secrets as the original authors, but we tend to share them without protecting them with other people? And when other people contact their friends to say, just tweak this proposal and bring it to me, and then we are surprised why we were not successful. We didn't protect our own. Therefore, our commercial value, we didn't realize it at the time when it was important. So that is why I'm encouraging you that when you see that a big business sends you an NDA, there's a reason for that. So likewise, as a small business, you should learn to do that. There's also another easier way. You can put a confidentiality disclaimer in your proposals, not necessarily a full agreement, but you are alerting the other person that this is my original work. I have given it to you for a sole purpose, for you to consider this proposal, and you are therefore restricted to share or copy or disseminate this information without my permission. So later on, when that very same proposal appears somewhere, one thing you know who signed your NDA or who received your proposal. So it's not going to be difficult for you to check who did I go to, who could have leaked this, who are the associates. But as entrepreneurs, especially small businesses, we have a need to please because we want opportunities. But that having said, it doesn't mean we can't protect our own. Every entrepreneur has a commercial secret. And earlier on the pitches, people shared what was their uniqueness about the businesses. So if you tell everyone that, and they don't buy from you, instead they pass the opportunity to someone else without protecting it, then you are gambling. So this session, because it's about more of your Q&As, we are going to allow, I don't know the MC how many people is going to allow, but we're going to allow questions so that we can.
Are you done?
Yes, sir.
Let's give her a round of applause. Come on, Mabopane. By show of hands, how many of you learned something from this presentation? Yeah? Okay, how many of you have got questions? All right, so we'll take 3. My sister, my brother, my sister. Hey, thank you. Hey, all right, so we'll take 5, right? Please come through, brother. Those of you who have called out, please come through as well. Please come through. This thing is so, like, rinkela go fat, but it's so important. Again, ratlakan ema brarabu mamelo tletsa soluso. Re tlo spanisa venya how re tse soluso. Again rabu again. O go mona teng o thola wa is again. And then it doesn't happen. What do we do then? All right, so we have 1, 2, 3, 4, 5, 6 questions. We'll start with you, my brother. Question.
Hello, everyone.
Yes, sir.
My name is Kumo, and I'm a founder of BB Farms here in Mabopane. So my question to you, ma'am, is that because farming is very broad, everyone can easily implement. So my question is that because of we are a startup, we approach a lot of people for funding and mentorship. So what happens if I do all those NDAs and disclaimer clauses about my company, but I see someone who does the exact same thing, right? But my problem is that the onus is going to be on me to prove that that is my pitch and idea and my IP. How can I proceed with proving it and the steps, and how far can I actually take it?
Okay, many thanks. So the very first principle about contracts is that they are binding to the people which concluded them, meaning the person that you concluded a contract with. You can't bind other people that didn't sign. So the person who would have offended this contract would be the one that signed, or his agencies or employees, because in a contract usually you must bind the person you are signing with and their agencies, because you don't know whether they've got employees or agents who are going to facilitate this. So you bind them in a clause in a contract. But how you recover damages in contract in South Africa is that you can sue, because when somebody violates a contract, that becomes a personal right. So you can enforce that claim via damages, but you need to prove, like you said, that there is a link between their breach of this confidentiality and your loss.
Okay, hi, my name is Maredi Mutapo. I'm into property investing. My question is, how do I deal with tenants that breach contract? But for me to take it forth, I need lawyers because I need to pay. I had a situation where I had people who were giving me a huge headache. I needed to kick them out, but unfortunately I was advised somehow that I cannot just kick tenants out because they breach the clause. I need to serve them with summons, then I need to take them to court. It's gonna cost me tons of money. That is money that I'm not willing to spend. How do I deal with such?
So, brilliant question. And briefly, I'm just going to share with you history of our country. The eviction laws in this country were developed because we were never the owners of the properties. We had no access to properties. So these stringent rules were designed to protect the disadvantaged back in the day. Now the disadvantaged are in a position to own properties and to lease. However, the law has not recognized that. It's still too stringent because you're going to spend a lot of money in litigation because you can't evict without a court order. But unfortunately, it is what it is. But please do Google what we call the housing tribunal, rental housing tribunal. You can try that as a form of mediation and see if you can succeed. But historically, that's where we are.
Good afternoon. My name is Muzi. I am the Managing Director of Muzi Industrial Solutions. I would like to ask a question. How do I protect an idea that I would like to present to a big corporation, for example, like MultiChoice, in order to better their services? How do I protect against the idea being rejected but later on utilized? Thank you.
Say, this is brilliant because this is how big ideas start. But wherever there's a big idea, there is value. When there is value, you protect your value at all costs. So MultiChoice, as an example, won't be different. They would have to sign a non-disclosure with you. Specifically, we would want to know which type of that IP. Because if it's a patent, remember, you can't now share it because it will lose its innovation. You have to patent it first. But if it's just an idea, you strictly hold them to confidentiality and, of course, other stringent clauses. Because obviously, you want to restrict them on who they can go and say, can you better this idea? Because that's the risk for entrepreneurs, is that you give someone an idea, they say to someone who's got more resources, can you better this thing? And then you lose. So that is important. Protect yourself by using contracts as instruments to run a proper business.
Hello everyone, I'm Karaba Sekhoa from Waparongo Sewing, a business dealing with manufacturing of school uniform in Karankua. Ma'am, I have two questions. We've been in business for over 20 years. It's a family business started by parents. Now it's over to us, me and my sister. So the problem is we manufacture school uniforms, so we approach principals and SGBs, the whole committee, and give them a suggestion to redesigning the uniform or even continue with the uniform that they have without even redesigning it. So now we've had cases whereby there's a new school, new principal, new committee, new everything. But then after the principal signs the contract stating everything in details that we are not the sole producer of the uniform, but since we are the one who designed the uniform, it's ours. But then now we see the designs that we created in other stores. And then when we approach the principal, it's a new principal. We are being told, I didn't sign this. The SGB has changed. Even worse, the principal tells other parents, in a form of a sabotage, that don't go to that store, they are lying and all those kind of things. So now I find my designs in other stores bad in Indian stores, that we had hoped that we were going to create job creation within our community because our youth, our black youth, is the ones that don't have jobs and employment at the moment. So that's the first one. Second one.
Let me answer it because I'm gonna forget.
Okay.
All right, so there are two things that are happening there. There's a breach of contract and there's also a violation of intellectual property. So both these become private rights. So you need to enforce them for you to get justice. So there's no system that automatically says, you get 10,000 if somebody violates your IP. So you've got to go to court. One, to hold the school accountable, because remember, you didn't enter into a contract with a principal. You entered into a contract with a school, and the successors of the school are bound by the same terms. So there's no escape there.
Thank you for that. We did that. And the principal went to an extent of changing the color of the school uniform. So now the name. So now we are stuck with stock of a school that does not exist because the principal changed the design and the color. So now we approached this to them, and then we told them, okay, this is how much the stock is worth. And then the principal is like, first, I didn't sign this again. Secondly, this is not the color of the uniform that we are wearing here. But then this was the contract made by the previous principal. Now I'm stuck with a uniform of worth 200,000.
Yeah, let's take it offline, because obviously you need a detailed approach.
Yes.
Yeah.
Thank you.
Hello everyone, my name is Mule. I'm the founder of Mashiko Fashion Studio. We mostly do ladies wear and a bit of men's for special occasions and whatnot. So my question is based on copyright. All right, copyright, as you said, it's automatically registered, right? So for a specific design, how do I then prove if there's another designer who disputes that that is my design? And it's
What
not-
type of a design?
Maybe a dress or, I don't know, I'm just giving an example.
Yeah, so there's a bit of problem with this issue of designs, especially for people who design clothing and labels and all that. But you can still protect that on a trademark as well. But this thing of copyright, you need to prove that you are the original person that designed that design, and the others are just copying from you. So like I said, the problem with enforcement of those rights is that you have to initiate legal action. So if you remember the Amaxhosa guy, when his stuff, which was too similar, was sold at Zara at some point, and it confused the customers, and customers were buying at Zara instead of him, he went to court to shut them down. And that's how it is done. It depends on the value. And if you want to protect your value, you must be prepared to shut anyone who's taking you out of business. That is unfortunately the position in South Africa, is that you have to enforce these rights in court.
Thank you. Thank you. Hello, everyone. My name is Kotatso, and I'm a managing director of Maseko Drillers. We deal with plumbing and water loss management services. So my question is, since today is about the legal contracting document and compliances, so I depend on making money through CSD. I have complied documents, everything is registered, and I get emails for specific RFQs. So one RFQ that I've had was one at OD Hospital. So I've got an RFQ. I went to purchase the sample of what they wanted. I went to present it to the supply chain. They approved me. I was given a purchase order. So after being handed over a purchase order form, now I need to find a purchase order financer to actually finance that purchase order. Now with the financing purchase order, they gave me a contract whereby I needed to partnership with them so that they can take care of their own money, because it's their money. They feel like they don't trust me. I'm this new guy, so they don't want to give me a large amount of money. So we had that partnership. I told them specifically what it needed to be supplied. I gave them the sample. I showed them everything. Well, they didn't do it. They didn't honor. Though I signed an agreement with partnership to them that we have a desirable framework whereby we want to make money on both parties, but that did not happen. So they didn't finance me, and then they instead went to make a presentation with another sample, which was declined by supply chain. And then I found myself being captured by this agreement that I signed with these purchase order finance guys, and the supplier wants to find out from me how long it's gonna take to get the payments so that he can process with the order. The customer order, they want to find out if this thing is gonna work. And then I had a time frame whereby everything needed to be installed and supplied, delivered and everything before the financial year end, which was happening in March, end of March. And they just didn't pay, and I didn't know what to do, and I lost the purchase order, just like that.
No. All right, many thanks. So briefly, there are just two issues there. You are sitting with a contract that was dependent on another contract, being the financiers of this purchase order. However, because they were going to invest money in that contract, they needed security. In other words, you needed to cede some of your rights, even some of your income. You may not have looked into it, but we call these security instruments. So if somebody gives you money for something where you're going to perform and receive remuneration for that performance. So what they do, they want you to cede. You literally cede, including your shares, including income that you are going to receive. When the debt is full, then they release the session, you can get your money. But they failed you in that respect. Instead, they circumvented you to approach your client. So you can sue for damages under those circumstances because they created a position that was awkward for you because you couldn't perform, yet they made an undertaking, and moreover, they circumvented you and they became the beneficiaries, so to speak, of your own hard work.
Sure. Yeah, you can clap, Thank you so much. Thank you so much, Yolelwa. Thank you for what you shared. Did you enjoy your presentation? Please, let's give a round of applause. Don't worry, we'll sort that out. Oh, no, don't go. Hey, you dropped the mic. Unintentional.